All right. Hey, everyone. My name is Mark Weiss. I'm a partner in the Washington, D.C. office at Baker McKenzie on the Antitrust and Competition team. My paper was class certification in the Ninth Circuit after Oleon. The article discussed the Ninth Circuit en banc decision in the Oleon case, which deals with which deal with price fixing allegations in the canned tuna industry. The decision clarified how to handle the presence of uninjured class members in class certification in Rule 23 classes. The defendants in that case based an argument on their economists, which found that almost 30% of plaintiffs could not effectively estimate their damages based on the model that the plaintiffs' economists had put forward. Based on that, they argued that there was more than a de minimis number of class members, and that as a result, there was, effectively class certification should be denied. As a result of that decision, the Ninth Circuit ultimately kind of declined that option from defendants and held that class certification should be denied. And the implications of the paper are fairly interesting. I think what we found is that the decision first creates a circuit split with certain other circuit courts, including the DC Circuit and the First Circuit. Some commentators, as well as the dissent, have suggested that the holding in that case suggests that plaintiffs will be able to bring much larger classes filled with uninjured class members, as well as that decision may contradict certain Supreme Court precedent that talks about the fact that every class member must have Article III standing in order to recover individual damages. I would say my paper rejects that notion and argues that what really needs to happen is a very detailed and precise predominance analysis under Rule 23b3. The analysis should consider a number of concerns, including due process concerns, Article III standing concerns, as well as class definition issues. I provide lessons for the relevant parties. The district court should conduct a serious predominance analysis in order to review and understand these issues. Plaintiffs are going to need to show that when they bring classes with uninjured class members, that those issues are not going to predominate and that the individual issues will not be effectively stronger or predominate over the common issues. And defendants are going to need to show that the existence of those class members do create actual serious predominance issues. They're going to need to be able to ask the difficult questions that plaintiffs may or may not be able to answer. Questions like how to identify and remove those class members from a potential class. So that's the summary of the paper. I hope everybody takes a read. I really appreciate everyone who voted for it, as well as concurrence for the nomination. Yeah, I think that's it. Thank you so much, and appreciate the time and attention.